Hi everyone, this is Mike DeBliss. This is going to be the first of what will be several podcast episodes on the topic of the Fourth Amendment. I'll begin with a little background information on the Bill of Rights. The first 8 amendments of the U.S. Constitution apply by their terms only to the federal government. So you might be wondering, how then do they apply to the states? Well, the U.S. Supreme Court has incorporated many of these rights into the due process requirement binding on the states through the 14th Amendment. Those portions of the Bill of Rights that are chiefly and fundamental to our concept of ordered liberty have been incorporated into the due process requirement that's binding on the states. So let's get right to it. What rights have been held binding on the states under the due process provisions of the 14th Amendment? There are a total of 10, beginning with the Fourth Amendment prohibition against unreasonable searches and seizures, and the exclusionary rule requiring that the result of a violation of this prohibition not be used as evidence against the defendant. So the two cases, landmark Supreme Court cases that are referenced here are Wolf versus Colorado and Mapp versus Ohio. Once again, the Fourth Amendment prohibition against unreasonable searches and seizures, and the exclusionary rule requiring that the result of a violation of this prohibition not be used as evidence against the defendant. The second is the Fifth Amendment privilege against compulsory self-incrimination. That Supreme Court case was Malloy versus Hogan. And these cases, by the way, go back as far as 1949 for the Wolf case, and for the Malloy case goes back to 1964. Third, we have the Fifth Amendment prohibition against double jeopardy. Fourth, we have the Sixth Amendment right to a speedy trial. Fifth, we have the Sixth Amendment right to a public trial. Sixth, we have the Sixth Amendment right to trial by jury. Seventh, we have the Sixth Amendment right to confront witnesses. That comes from the case of Pointer versus Texas back in 1965. Eighth, we have the Sixth Amendment right to compulsory process for obtaining witnesses. That comes out of the case of Washington versus Texas. Ninth, we have the Sixth Amendment right to assistance of counsel in felony cases. That is the case of Gideon versus Wainwright. That was the case that established that those who are indigent and cannot afford paid counsel or private counsel are entitled to the services of the public defender. The Sixth Amendment right also includes misdemeanor cases in which imprisonment is imposed. So it secures a right to assistance of counsel even in misdemeanor cases in which imprisonment is a possibility. And 10th is the Eighth Amendment prohibition against cruel and unusual punishment. That comes out of the case of Robinson versus California. Now, one thing that I thought was interesting is that what provisions of the Bill of Rights have not been held binding on the states. And there are two, and it's very easy to get these confused and think that these provisions of the Bill of Rights are binding on the states, like the laundry list that I just provided. But these two are held not to be binding on the states. The first is a right to indictment. So the right to indictment by a grand jury for capital and infamous crimes has been held not to be binding on the states. Now, interestingly enough, the state of New Jersey does have a right to indictment. There is also the possibility to waive indictment and plead to what's called an accusation. And that happens frequently in cases that are selected by the prosecution for easy resolution, and basically the defendant has the right to accept, in many cases, what is a generous plea offer in exchange for waiving the right to indictment and pleading to an accusation. An accusation is nothing more than a charging document, and it looks just like an indictment. The difference, of course, being that the case hasn't been presented to a group of 23 grand jurors, and they haven't had the opportunity to hear the evidence and vote and determine whether there's probable cause to believe that a crime has been committed and that the defendant is the one who committed it. So in the theory here with the right to indictment is that it is a safeguard to the prosecutor's abuse of discretion in perhaps maliciously indicting an individual who is otherwise innocent of the crime. The second provision of the Bill of Rights that's held not to be binding on the states is a prohibition against excessive bail. It's not yet been determined whether the Eighth Amendment prohibition against excessive bail creates a right to bail or whether it simply prohibits excessive bail where the right to bail exists. And along with that, whether it's binding on the states. However, most state constitutions do create a right to bail and prohibit excessive bail. In New Jersey, we have experienced a groundbreaking change to our bail, reform to our bail system, and that is a topic that we will get into in a future podcast. So stay tuned for the second episode of this podcast, and feel free to leave a message on this podcast feed or on YouTube if you have any questions about what I've talked about up until now.